Okay, thank you, everyone. I think we're all having a lot of fun so far. I'm very, very, very excited about panel 3 on algorithmic adjudication. I have learned so much from every panelist here. So the way we're going to do it for this panel is our lead-off speaker will be Chris Slobogin from Vanderbilt, and he'll give a few remarks. And then we're going to kind of cycle through presentation by presentation, and then we'll gather again together here on the dais and have a conversation amongst ourselves, and hopefully include many of you in a great Q&A session. So without further ado, Chris.
Great. Okay, I've been told I have to use the mic. I hope I don't blow your eardrums out with this, because I have a naturally loud voice anyway. So I have been tasked, we talked about this beforehand, and I have been asked to defend the use of algorithms at sentencing in order to assess offenders' risk. It's a dirty job, but someone has to do it, so I'm going to do it. Okay, and I think it's a very important issue because more and more states are using risk assessment instruments to determine the risk of offenders and either enhance their sentences or find alternatives to prison or change somehow the dispositional consequences. Now, Eric sort of blew my cover or stole my thunder because my first point and my main point is that we need to ask the rather primitive question, compared to what? Okay, that's going to be my main defense of algorithms, is compared to what's out there, algorithms are preferable. I mean, you've heard that saying, democracy is the worst form of government other than the other forms of government. Well, algorithms are not great, but they're probably the best thing we have going when it comes to assessing risk at sentencing. If we are going to assess risk at sentencing, probably we should go with algorithms. So let me just go over 3 strains of research that support that proposition. The first one is, and a couple people this morning already mentioned this, is that despite what judges may think, their subjective judgments aren't very good. Their subjective judgments about violence are not very good. They're driven by false stereotypes and by bias. And partly for that reason, as metadata and meta-review after meta-review has found, predictions based on algorithms are better than predictions based on unstructured decision making. Okay, it's a finding that's been made over and over again. Now, there was a study that some of you may be aware of by Farrad and Dressel, which got a whole bunch of play, which suggested otherwise. But if you look closely at that study, it doesn't show that. In fact, I think, and I'd be glad to talk about this later, I think it actually confirms that algorithmic prediction is better than clinical prediction. And then this third line of research is very important to understand as well, and that is professional overrides of algorithmic judgments, at least if the overrides based on a factor that was considered in constructing the algorithm actually decrease accuracy. Okay, and this is important because a lot of judges and mental health professionals think, oh, we'll use the algorithm as a starting point and then we'll make adjustments. That's the wrong thing to do, at least according to social scientists, because what you are doing is reintroducing the false stereotypes and the bias that algorithms are meant to prevent. So this is the case in favor of algorithms. And I could sit down right now, but I'm not going to because I have 7 more minutes, right? And I want to make the point that I think I'm sorry, I didn't introduce myself to you, Ted. Is that you asked this morning? Is that right? Which is, okay, that's the accuracy issue, right? But what about other values? I mean, I would argue that just because, even if you agree with everything I just said, that doesn't mean we use any old algorithm, and then we should be very careful what the kinds of algorithms we use in the sentencing process. And I have to admit that right now, there are very few, if any, risk assessment instruments that actually meet the gold standard that I would impose on risk assessment instruments. And what I want to do now is, so you can get a sense of what my gold standard is, I want to describe 3 risk assessment instruments to you that are used right now at sentencing. Some of you know about some of these, but I think you'll still find them very interesting and surprising. This is the Violence Risk Appraisal Guide. It's used in Canada and a number of American jurisdictions. As you can see, it relies on 12 risk factors, including one score in the psychopathy checklist, which is obviously a measure of psychopathy, one's official diagnosis, age at time of triggering offense, and so on, including a number of antisocial conduct kinds of factors. The numbers you see here are added up. You get a point total. And then people are assigned to one of 9 bins. And as you can see, if you get a score of 0 to 6 on the VRAG, it's associated with 35% probability of recidivating within 7 years, and so on. So that's the way the VRAG works. These 12 factors were 12 of dozens of factors that the researchers behind the VRAG explored, and they came up with these as the most predictive. Then you have a Virginia risk assessment instrument. Those of you in this area know Virginia's been a pioneer in the use of risk assessment instruments. This uses 5 risk factors: age at time of offense, gender, prior adult felony convictions, prior adult incarcerations, and whether the person was on parole or probation at the time of the offense. If you get 32 points or more on this, the recommendation is for prison. 31 points or less, the recommendation is an alternative to prison. Okay? So the VRAG and the Virginia instrument that I've just shown you were generated by government-sponsored entities. So I can more or less tell you about their internal workings. But as some of you know, some risk assessment instruments are much less transparent, and probably example number A is instrument that was mentioned this morning, the compass. Okay, now it purports to talk about evaluate a number of different aspects of an individual, criminal involvement, relationships, personality, attitudes, and so on. And then based on that, it comes up with a determination of whether someone's high risk, medium risk, or low risk in terms of, I don't know if you can see this, violent recidivism, general recidivism, and pretrial release risk. That sounds pretty cool. It actually looks a little bit more elaborate than either VRAG or the Virginia instrument. The problem is we don't know how the compass arrives at its results. Okay? Equivant, the company that developed this, will not reveal how it developed this instrument, and it uses trade secret law to hide behind that. Rebecca has written quite a bit about this. So I cannot tell you what the precise risk factors are or the weights assigned those. So I'm much more comfortable with the VRAG and the Virginia instrument than I am with this. But to tell you the truth, I'm not comfortable with any of these instruments because I think to a greater or lesser extent, they fail to adhere to what I consider three fundamental principles that all risk assessment instruments ought to abide by. And now I am running out of time, so I'm going to go over this very quickly. But the three principles are what I call the fit principle, the validity principle, and the fairness principle. And this gets to Ted's question. Okay, the fit principle is that the algorithm should answer the precise legal issue at stake. So in other words, the risk assessment instrument ought to give us a specific probability that a specified outcome will occur within a specified period of time unless a particular intervention takes place. The courts and the legislatures have been absolutely horrific at figuring out what the probability of a particular outcome should be and delineating what that should be and giving that message to the courts and clinicians. We have a gigantic literature on the jurisprudence of culpability. We have an absolutely paltry, pathetic literature on the jurisprudence of risk, and we need that. The second principle is the validity principle. Fit principle basically has to do with external validity for those who are scientists in the room. Validity principle has to do with internal validity. And here, this is where Daubert would apply if anybody took Daubert seriously. This is where it would apply. We'd make sure the instrument's normed on the appropriate population. We'd make sure it's up to date. And we make sure it could differentiate high and low risk offenders fairly well, I would argue 75% of the time. The final principle, and this is my last slide, Richard, is the fairness principle. It's much less concrete than the other two because it aims at getting at concerns about equality and about dignity and so on. The basic idea is algorithms should minimize use of biased or otherwise suspect risk factors. Well, that's not very helpful. It's pretty vague. So what I mean by that, some of you know about the Supreme Court decision Buck versus Davis, decided 2 years ago, where the court said we only punish people based on what they do, not on what they are. Well, that's pretty problematic for the instruments I showed you because remember a lot of them use age and gender among other immutable characteristics or other characteristics that don't have much to do with conduct. So the concern there, of course, is that you can't base any criminal dispositions on any of the risk assessment instruments that I just showed you. But here's the counterpoint that came up, it was made by the Wisconsin Supreme Court in the Loomis case. It appears that any risk assessment tool which fails to differentiate between men and women will misclassify both genders. In other words, if we rely solely on criminal history, which is what Buck versus Davis suggests we should do, we will be inaccurately classifying people in groups that we don't want to discriminate against. Just to give you a very concrete example, a 20-year-old male who has psychopathic tendencies and has committed one particular offense poses a much higher risk than a 40-year-old woman with schizophrenia who's committed the same offense. But if you only rely on criminal history, those people have identical risk profiles. And that doesn't make any sense, at least to me. I think we need a much more nuanced approach to risk assessment. So basically, and I'm not going to go over this, you could read it if you want, but basically, all four of these things are designed to get at this idea and the fairness principle that I espouse, which is that we ought to look at each risk factor and figure out its incremental validity, the extent to which it adds to the validity of the instrument, and balance that against equality and dignity concerns of the type that are referenced in this part of the slide. Thanks.
Wonderful. So as our next speaker gets ready, I think I might allow maybe one or question from the audience. If someone has a burning question, ask Chris right now.
Burning question.
No. Oh, yes, one.
If the risk assessment is determining whether somebody is 35 or 75, for example, percent more likely to recidify in the next 7 years, then what's next? Is then the judge just going to incarcerate them for 7 years to prevent that?
That's a very good question. Of course, it relates back to what we talked about before lunch, right? I mean, just because you have a prediction doesn't mean you have to do a particular thing. And in particular, you don't have to send them to prison. And I and Sandy and various other people have argued that it's actually pretty idiotic to have a knee-jerk reaction of imprisonment, even for a person who's high risk. There are lots of interventions, and one of the things here is that risk factor, to the extent you can do so, you need to pick risk factors that are dynamic, what social scientists will call dynamic, that you can do something about. And a lot of people are risky because they abuse substances, because they're impulsive. There are ways of treating those kinds of risks factors that don't involve putting a person in prison. There's some very successful community programs that have reduced significantly the recidivism of violent youth, not just penny ante, juveniles who commit penny ante crime, not penny ante youth, but juveniles who committed penny ante crimes. Violent juveniles have been very successfully treated at much lower cost than prison through interventions that don't involve detention.
Thank you so much, Chris. Okay, our next speaker is Christine Goodman from Pepperdine, and she is going to take it from there. Thank you so much, Christine.
Thank you. Good afternoon. Is that too loud? All right, good to see you all here today. I'm going to be talking about a couple of things. The first area that I want to address is algorithms and access to justice. And then I'm going to talk just a little bit briefly about the problem of biased inputs, adding to some of the conversations that we've already had. And then I will focus a little bit on the changing nature of justice, all in 7 minutes. So let's see what we can do. Okay, so on the access to justice issue, one of the things that is important to think about is that we can expand the opportunities for legal representation using computers, using machine learning, using artificial intelligence, using algorithms. And so in some sense, a greater number of people can be represented who couldn't afford to pay the price of attorneys at $100, $200, $500, $800, $1,000 per hour. In the criminal justice system, obviously, if you can't afford a lawyer, you're entitled to one. But again, greater representation can be had if we have basically superhuman lawyers, right? Imagine if you could bill efficiently and effectively every second of every day. You don't need a lunch break, right? You don't need a rest. And so to that extent, one thing that the algorithms and computer models can help us do is to provide access for a greater number of people. But the real question then becomes, is more better? Just because I can do more law, I can do more research, I can, put out a brief or something like that, is that going to be a better representation for the individual client? And that's a question I think we can explore in more detail in the Q&A. The San Francisco DA's office has started using some tools to help prosecutors spend more time focusing on which charges they should bring in particular cases and not wasting their time with filing charges that they may not be able to prove later. Is it helpful to have the DAs make more appropriate charging decisions? Yes, it is. And then they can use their time more efficiently and more effectively for prosecution. Similarly with defense lawyers, if they could have the benefit of tons and tons of bots to help them with their research and things like that, they could explore all the different avenues of potential defenses for their clients. So things actually would be more effective. Obviously, with translating, that is another skill that is useful. But in terms of credibility assessments, I just want to speak briefly about that. AI may be better than what we've been thinking about with lie detector tests, and they're obviously not acceptable in many situations. But the vast amount of information that we will be able to use can help with credibility assessments. If I have exposure to a broader world, more stories will actually ring true to me as a juror than they would otherwise. How many of you step off the curb without looking both ways? Okay, and you're from California, right? And we have this crosswalk thing where it's okay to just step off because they're supposed to stop. Even if you don't look both ways, maybe you look to the way that the cars are supposed to be coming, right? Well, I just got back from a semester in London, so I had to retrain myself to look the other way. And now I'm back here and facing the same challenge, but thankfully the cars stop. But if I told a story about looking to my right as I stepped off the curb and seeing a car flash by, you wouldn't believe that, because here I should be looking to my left, so my story is not credible. All right, so just the opportunity to have greater exposure of information, I think, can help make more accurate credibility assessments. Now, it can also mean more lies are going to be found out, right? If you say you were someplace and then the facial recognition software sees that you weren't there, then it could be used in that sense too. So I think by expanding examples, that credibility can be enhanced. So the other thing, though, I want to talk about is the challenge of biased inputs. Machines, what they do is they replicate the inequalities that have gone into the program that are already in the data. Some of the problems that we need to think about in terms of biased inputs, of course, is that outliers are disregarded. All right. So if you're the unusual example, the machine doesn't take that into consideration in deciding or in applying the appropriate standards. The machines don't understand context necessarily, and minority data is just that. It's minority data. It's not the majority, so it's not going to be as recognized nor treated as important. So one of the things that we need to remember is that, not just historical context matters, but our algorithms are like our children. We have to teach them which associations are good and which associations are bad, because they go through the world and they see things and they make connections, but it's kind of our job to make sure that those connections are understood. So that's why I think it's incredibly important to keep collaborating between attorneys and those of us who are trained in the law with the designers and those who are creating the technology and the algorithms. All right, I have 2 minutes. What do I have? Oh, okay, good. All right. So then the next issue that I want to address is basically this notion of justice, and what is it that we are thinking about when we're trying to make sure we have just results, but we're dealing with sort of a binary system, right? In a numbers world, you have a 1 or a 0. So how do you figure out what justice entails in that context? Are we thinking about maximizing equal treatment to make sure that likes are treated alike? Are we caring about anti-classification? Basically, the numbers are putting people into groups. That's the whole point of using this data to make predictions, is that people fall into certain groups based on their attributes that our other speakers have talked about. And so what we need to think about is which attributes are we going to maximize for, which inputs, as Chris was discussing, do we need to weigh more heavily, and which ones are we going to give more of a less of a concern for. But you have to recognize that in making that choice about what you're going to allocate additional, be a heavier factor or a lighter factor, making that choice is a choice made by the human. And so therefore, as you mentioned, getting the human back into the loop, while that is, I think, really important because the computer doesn't understand justice, that also leads us to decisions that may end up being even more biased. So as we know, fairness is not a mathematical concept. It's not something that we can quantify. And so I'll save more for the Q&A. But basically, what I want to leave you with is just a few quick conclusions, and we can debate, whether or not which of these are more important. I think judges need to be involved in the process, despite the fact that they do have their own biases. They know some of the pitfalls and some of the problems with trying to decide on credibility issues and other issues. So to the extent we could get judges involved in post-training auditing of algorithms, I think that could be useful, and I'll be interested to talk to Chris about that. Obviously, diversifying the data sets, diversifying design teams. We've talked about that in some of the other panels. And then I think the other thing is to really emphasize more on supervised machine learning, where the machine goes through its process, it learns what it learns, and then the human comes back and rechecks that answer and retrains the machine, even though that may, again, lead to some biases. I think that would give us bigger hope for more success. And then finally, increasing transparency, the black box and unraveling it, but we have the trade secret issues. So that's all I have for today. Thank you very much.
Wonderful. Thank you so much. As before, maybe I'll allow a question from the audience if someone has a burning question they want to ask right now.
Yes. The UK example? Oh. Sorry, didn't get to that quickly. In the UK, what they've done is, if a computer is responsible for making a decision that either denies you a benefit or something like that in an administrative process, you have a right to know that a computer made that decision and then can seek to get human intervention. So they have to actually disclose that this was done just by rote. Of course.
Wonderful. Thank you so much. So our next speaker is Sandy Mayson from the University of Georgia. Take it away.
Hi, everyone. It's a pleasure to be here. Thank you so much to the organizers for having me. Going late in the day, I guess it's either a liability or a gift. Much of what I had planned to say has been covered, so I am going to try to fly through some of my early slides and get to the stuff other people haven't discussed. The question Richard posed to the panel for us to address is algorithms in criminal adjudication, will they be a net benefit? And I think they will, yes, asterisk, what everybody else has said, depending on what they're used for and how they're used. Minor caveat. What matters more than the algorithms themselves is how the system that uses them defines their objectives and ensures accountability to those objectives. That's where the game is really at, and here's my more detailed yes, awfully vague, but yes, algorithms will be in that benefit if algorithmic methods are deployed in the criminal justice system, number one, to help us understand patterns and catalysts of harm, effective methods of harm prevention, and sources of racial disparity. So first, just to help us understand where the problems are. And then, number two, in our response to that understanding, if they're deployed to maximize human liberty and flourishing, we all have to figure out how they do that, how we do that, and to eliminate or reduce racial disparity in the system. If they're deployed in this way for these purposes, and if we put a lot of thought into figuring out what that should look like, then yes, I think they'll be in that benefit. More specifically, in my allotted minutes, I'm going to defend 3 theses respecting racial disparity in particular. Some of this is just a reprise of an article I wrote called Bias In, Bias Out, so apologies for repeating stuff I've written already. Thesis number 1, algorithmic methods can mitigate racial disparity. Thesis number 2, algorithms expose the incoherence of the ideal of inequality, sometimes called color blindness. And thesis number 3, machine-learned algorithms, in particular, should presumptively include race as an input variable. I'm defending these theses in part because Richard asked us to be provocative, so I'm doing my best. Thesis number 1, algorithms can mitigate racial disparity in the criminal justice system. It's not because they're race neutral, they're not, but rather because they force us to confront structural inequality in the system. They're not race neutral. Nothing is race neutral in a world of racial stratification. It's an impossibility, and in the context of criminal justice risk assessment, which is what most algorithms in the system currently are, the problem arises because of the base rate problem, which This article by ProPublica in 2016 exposed that when you've got different base rates of the thing you're trying to predict across two groups, it is impossible for those predictions to be equal across the two groups by every axis. I'm just going to assume that this group is familiar with this controversy and why it's impossible. If not, I'm happy to talk more about it in the Q&A. So it's not that they're race neutral. It's something else. But before I get to the something else, I had a slide on the compared to what question. Other people have covered it. Compared to humans. Are humans better with respect to racial disparity? Really hard to say. I don't think there's clear evidence one way or the other. There's these two recent studies, Megan Stevenson's Assessing Risk Assessment and Action in Kentucky, and then Ben Green and Yelin Shen did this Mechanical Turk study of volunteers online, both of which suggest that the thing that produces the racial disparity in a risk assessment system are the humans when they get involved and when they depart from the algorithmic prediction. On the other hand, Megan's last piece with Jennifer Doliak, Algorithms in the Hands of Humans, suggested that if the humans in Virginia had adhered more closely to the VRAG, I think the racial disparities they found would have been more extreme. So we don't know one way or the other, and it surely depends on the local context, whether an algorithm on its own or an algorithm with humans or humans on their own would produce more racially disparate outcomes. But we do know that algorithms, this is what I'm going to argue to you, have an advantage over humans in helping us address racial inequality and racial disparity, which is that they make it apparent. Prediction is always a mirror. Other people have said this today. When we predict, we look to the past to make guesses about the future. We project history forward. But algorithmic prediction, data-based prediction, is a particularly crystalline mirror. So big data predictive models show us what our past has looked like. And what do they show with respect to racial disparities? They show just stunning and persistent racial disparity in arrest rates through time. This shows arrest rates from 1980 through 2014. Here's some other charts showing homicide victimization and offending rates by race, 1980 through 2008. This is the problem. And if we're going to fix racial disparity in predictive models, we have to fix the disparity in the underlying data. To fix the disparity in the underlying data, we have to understand it. What is this? What are we looking at? We need to know, do these data show us what we think they show us? Do they fairly represent the harm that we want to avoid, that we're trying to predict in the future? Sometimes they don't. In the case of arrests, it's been often assumed that arrest data equates to crime data, that somebody more likely to be arrested in the future is more likely to commit a crime in the future. But of course we know that arrest doesn't cleanly correlate with commission of crime, and there's a racial skew in rates of arrest versus rates of crime commission. So if we're looking at past arrest data and we're predicting future arrest, there is going to be an unjustified racial skew in that predictive model. There was a recent example in the healthcare context, a big healthcare algorithm that was being used to try to predict people who were at risk of serious injury or serious medical complications in the future. Turned out to predict really badly for people of color, and it was because the proxy variable they had used to represent serious medical condition was a person needing expensive medical care. But guess who needs expensive medical care? Rich white people. And so because the proxy variable in the data was not a fair representation of the actual harm the system wanted to avoid, it introduced racial skew. Secondly, though, if the data are representing fairly the thing that we want to avoid and predict in the future, and the racial disparity is a function of a real disparity in the rate of that thing happening in the world, then we have to address that problem societally. We can't fix it in the predictive models themselves. my argument in my writing and here before you today is that that is not a reason to reject algorithmic or big data-driven models. Right? And if we're going to fix these problems, we need to be able to see them, and we can see them better with the data. And what we do becomes the question. Is my time up?
No, not at all.
Okay. You moved. You moved. All right, tell me.
Okay.
Can you flash me a minute when I'm a minute to go?
Sure.
You don't know what you told us during the phone call.
So that's really when algorithms have this advantage, that they show us our reality. They show us the past that will also be our future if we keep up business as usual. Second thesis, algorithms expose the incoherence of the ideal of color blindness. So it is basically orthodoxy that race, or as Christopher said, factors that correlate closely with race should not be inputs to predictive algorithms in the criminal justice system. And I think the central intuitions are two-part. Number one, that it'll be bad for already disadvantaged groups in the criminal justice system that right now, here and now, usually means black men. And intuition number two, the Buck v. Davis quote, we're supposed to be punishing people, managing people in the system because of what they do, not who they are. And I think that both of those intuitions are wrong, and algorithms help explain how. So first of all, it is wrong that including race as an input variable to prediction will categorically be worse for black men in the criminal justice system. And to explain why that's so, I have two examples. The first is an anecdote I tell in the bias in, bias out piece, purely anecdotal, no scientific basis for this, but I used to be a public defender in New Orleans. When I was a public defender in New Orleans, almost all of our clients were black men, and almost all of our clients had an arrest record. So if you met a new client who was a black man who had, say, 3 past arrests, that meant he'd been living in New Orleans. Because if you're a black man in New Orleans, you were likely to be arrested. It just didn't signify very much for a black man to have 3 past arrests. If you met a new client who was a white man who had 3 past arrests, that was kind of scary. Like, that meant this person had an unusual ability to attract law enforcement attention in the city of New Orleans. So the identical race-neutral traits had a different meaning because of the person's race. And that is because in our society, race is not just skin pigment. It's not just a bodily characteristic that can be extracted from a person's profile without changing the significance of the rest of the profile. John Kleinberg, in a recent paper, has demonstrated quantitatively that an algorithm, a machine learned algorithm that includes race, that considers the meaning of all of the other criteria in light of race, can do much better at predicting future grade point averages for college students, so success in college, than a race-neutral algorithm. And Isa Kohler-Hoffman has a theoretical piece exploring the same phenomenon. I don't want to take more time than I have, but happy to talk more about this in Q&A. In light of the fact that including race can increase the accuracy of algorithms to the benefit of the very groups we are concerned about, I think presumptively race should be included as an input variable, at least to sophisticated machine-learned algorithms. I will stop there.
Okay, so why don't we get the band back together here, and while we do that, can we have one question maybe for Sandy, if someone has a burning idea they want to express?
Yes, sir.
Yeah.
So you think that race should be an input in the algorithms, but do you think that race should be an input in the algorithm deciding sentencing rates, or is that a separate algorithm that should be
Great question. Sentencing is really complicated because there are two, and even this is a simplification, but two central kinds of determinations to be made at sentencing, and one is about blame and what a person deserves, and one is about risk, what risk the person presents, and then I guess the second half of that determination is how to manage the risk. The blame question is a moral question. The statistical question about the likelihood of a person having some future outcome is a purely statistical, empirical question. And it's my position, so this is a point where I disagree with some of the things that Chris said earlier. It's my position that there's no moral criteria for the input variables that should go into that empirical question. It's just an empirical question. We should consider every variable that gives us a more accurate answer. And then the second half, what do we do in light of the empirical information we glean? That has moral components too. So on the blame question, what does the person deserve? And on that, how should we manage whatever statistical risk there is? Race, we should be very careful in how we think about race. But as far as the statistical question, I think it should go into the mix like every other variable.
No, let's finish with the panelists first. So we have Andrew Selbst from here at UCLA as our final presentation.
Thanks so much. Just to preface this, it seems like we've heard a lot today from people that were sort of, in passing, arguing against reflexive rejection of algorithms, but we haven't heard anybody reflexively reject algorithms. Or not reflexively, for that matter. I'm still a more middle grounder, but I'm net pessimistic, and that probably puts me as the most algo negative person here. So that's just the first thing. And I'm trying hard to not make this entire spiel a diatribe against the compared to what question, because it's one of my pet peeves, but we'll see. Okay, so I'm going to actually try to answer that as well. So the premises under which, we're thinking about algorithms and adjudication on this panel, and so I want to think about, sentencing algorithms or risk assessment, but algorithms and adjudication in the criminal justice system. The premises under which we're willing to use them are judges are not good at predicting risk, or they're biased, or they're biased. Right? The algorithm is statistically better at predicting risk. The algorithm, if not naturally less biased, can be tuned in a way so that it can be less biased. And algorithms will make errors, but the errors they make will be fewer in number, and then there's a recognition that they'll be differently distributed. We don't necessarily know how. Right? Those are the premises, and if we can make those errors less, and if we can make it less biased, we're theoretically willing to use these things. I want to say two things about this. The first is, in the best case, what the algorithm inescapably does is replace an individual assessment with statistical assessments. Right? These statistical assessments are not better grounded in reality than individual assessments. They're largely impossible to oversee and appeal on an individual basis. So I don't think, if we care about individualized assessments, that they accord with what we're trying to do in the criminal justice system. And frankly, I think on balance they probably shouldn't be used. The second point I want to make, though, is if we think we should use algorithms, and this echoes a point that Chris made, and actually I think several people made, using them with humans is the worst of all three possibilities, right? Commit to the bit, right? If you're going to go and use algorithms, stick with it, because as soon as the humans get involved again, everything gets worse. Okay, so why do I say it inescapably removes individual determination? Well, for one, there's the obvious point, right, that an algorithm trained on data is making judgments about you based on people that look like you in the data, right? So not what you do, but who you are. But that's kind of a facile point. And that the reason is because pure individualized decision-making is kind of just a myth. I've written about this. Jane has written about this. A couple other people here have. In general, for those unfamiliar with the argument, anytime we make any sort of consequential observation about anyone, we are doing the following syllogism. 1, observe X fact about Y person. 2, fact Z is always or often true about people with trait X. 3, fact Z is therefore likely or true about person Y. So think about it, right? How do I know that I should not drop this iPad? Well, I say, 1, this iPad is an expensive piece of electronics. 2, expensive electronics are often fragile. 3, this iPad is therefore probably fragile. Every observation we make is is in this form. So this scales up. This is all an algorithm is doing, right? Traits X, Y, Z, A, B, C are true about this person. People with X, Y, Z, A, B, C are often X, yada, yada, yada. So that's not really a great argument. So what is it that we care about when we think about an individualized determination? Why does the criminal justice system think this is really important? Why is due process centered around it? For me, it's inexorably connected with the right to appeal or the right to contest the decision. Right? Essentially to have some sort of structured conversation with the decision maker that theoretically makes it possible to change the outcome. So, can algorithmic decisions be appealed effectively? Well, presumably that means you're looking to correct errors. There are other reasons to appeal, such as procedural justice, like the importance of feeling like you're being heard, but even that sort of blends with the idea that you can change the algorithm's mind, because if it's just, yeah, I hear you, but no chance of changing someone's mind, that doesn't do anything. So it's all in this idea that maybe for some value of error, we can say, you made an error, please change it. So one possibility is there's actually a data entry error in the inputs. Right? This should be easily appealable. If you have access to the inputs, you say, oh, they just screwed up. This shouldn't have been calculated this way because they got my data wrong. This is what happened in Loomis, but he lost that case. So why isn't that working? Well, there's trade secret issues, access to the data. People don't necessarily think you have a right to challenge the inputs. Okay, so that's theoretically not an algorithm problem. That's a law problem. Sucks too, but fine, set that aside. Then besides the input errors, what does it mean for the algorithmic prediction to have an error, right? So they get the prediction wrong for a specific person. Well, if an algorithm says you're 70% likely to recidivate, that's unfalsifiable, right? So you can't look at an individual person and say whether that's right. It's just philosophically impossible. And because it's philosophically impossible to falsify it in the individual case, you can't go say you made an error in my case. That's just not an available thing. Okay, so then maybe you can use statistical analyses, RCTs, right, other kinds of statistical validation to say that they're getting the prediction wrong in general. But they're predicting the future based on data with lots of individual choices that go into what data to collect, what kind of questions to pose. The only way that we know how to, other than waiting until the future either comes true or not, the only way we know how to validate these things is essentially reserving test data and doing an internal validity check. But that doesn't address any of the problems with the data, the training data being unrepresentative of demographics out in the world, right? We could test for racial disparities, for example, by changing inputs, race bits of inputs and seeing if there's a racial disparity, but that doesn't tell us whether there's an error in the accuracy rate. It's just not a coherent question to ask what is the error of a probabilistic prediction in this way. So because it's effectively unappealable on an individual level, it means we inherently get rid of the notion of individualized justice when we use this in the criminal justice system. If we're going to approve this, we have to recognize that that's what they're doing. And that's the stakes of the debate that we're talking about. Maybe that's a good thing. I don't think so. I don't think that's what we want to do in the criminal justice system, and I don't think that's what it's supposed to be about. But that's the stakes. One other solution, I should say, that's proposed is explainability. Right? There's a lot of discussion of explainability, interpretability, but that's just not going to work either. So here's a way too brief reason why we could think of two categories of AI, algorithms, machine learning, whatever, two categories that are out there, right? One tries to replicate human capabilities, but faster, more reliably, and more consistently. One tries to go beyond human capabilities. The one that's trying to replicate them is like the machine vision system in an autonomous vehicle. What it's doing is it's looking at a field of view saying tree, sidewalk, squirrel. It's really easy for a human to look at that and say, right, wrong, no, that's a dog, right? The whole point is it's replicating human categories. But all the algorithms that we're talking about in employment and criminal justice and other things like that are premised on the idea that it's going to be statistically better than humans. And so it doesn't matter how you try to explain it. In there, like, it's just an alien logic. It's not something that humans can oversee and check in any sort of reliable way. So it's possible to learn what a system is doing. So in Virginia Eubanks' book, Automating Inequality, she reviews the algorithms that they use in Child Protective Services in Allegheny County in Pennsylvania. And it's a relatively simple point system with a bunch of factors. It's actually one of the more transparent government systems out there. And it has some truly odd results. So she recounts this story where a 6-year-old who showed evidence of possible sexual abuse and homelessness rated relatively low danger, while a teenager who sleeps on the couch in a cold apartment ended up rated highly because of some of the quirks of the system. But what's interesting is she was talking with the people who are used to seeing these outputs, and they called those numbers. They knew they were coming before they got entered in, even though the inputs are weird. They work with this stuff every day. So you might say, right, that a judge who sees these risk assessments every day could learn the system and therefore learn when it's appropriate to deviate. But that second part doesn't turn out to be true. That second part is you're learning the system. You're learning the logic of the system. But you're not learning how that logic of the system differs with the norms that you carry as a judge, as a trusted member of the legal profession, right? You don't know how to compare them. You only know how to predict what it's going to do. And so there's still no real useful way for judges to go and overrule an algorithm without making things worse, statistically speaking, right? Either you trust the statistics or you trust the professionals, but once you start doing both, the worst happens. Okay. Just a little bit more. Or do I have time? No, I don't.
You have a little more time.
Okay. So, returning to Loomis, well, actually, you know what? This point was made. What is this?
Okay.
Yeah, screw it. I'm done. Rant over.
Okay, well, this is the first time we've all been up here when someone finished a presentation, and so I'm bursting with questions. I hope some of you are as well. Maybe I can ask if any of our panelists want to respond to what Andrew said or what anyone else said right off the bat.
Yeah, I mean, I guess I thought some of what you said was in tension with itself. If algorithms are not individualized, but a clinician is not really individualized either, right? Clinicians are relying on stereotypes as well. Then it's really impossible to cross-examine either. I taught mental health law for years, and some of you who know that area may know about Dr. Grigson, also named Dr. Death. He testified in 120 death penalty cases, always for the prosecution. The guys were always put to death. He was undentable during cross-examination because he'd just repeat why he thought he was right, and it was very, very difficult in any way to get underneath what he was saying. In contrast, with an algorithm, as you say, you can contest the data. Maybe the guy never was arrested, and you can obviously dispute that. But in addition, if a factor was not considered in the construction of the algorithm, you can certainly bring that up. The example that John Moynihan always uses is if the guy's become a quadriplegic since the crime, that obviously is relevant and would presumably undermine the entire prediction. And that's obviously an extreme example, but there are lots of examples like that. So I guess I think there's a little bit of tension about what you're saying, and also I disagree with your idea that you can't cross-examine an algorithm in the fashion you talk about.
So Sandy, do you want to jump in as well?
Just a very quick point, which is to say, it also sounds to me like a lot of that argument presumes that the algorithmic outputs will be used as the basis for coercion or some unpleasant state action as opposed to support or some pleasant state action. So in the criminal justice system as a thought experiment, what if we used risk assessment algorithms only to identify people in need of increased support to mitigate risk? To what extent would all the concerns about appealability still apply?
So just to make sure everyone's ganging up on Andrew, so Christina has a comment as well.
Well, I want to say that I actually agree with you about your pessimism. All right, so I too am pessimistic for the reasons that I explained. But one question that I would like to ask is about the judges. I really feel I wonder how the judicial process. You were saying the judges can't figure out what the algorithm has done. They only would see what they would do differently. But I think part of it is that in seeing that, the judge making the determination that he or she would do something differently from the outcome recommended by the algorithm, that might be an opportunity to train and reassess the algorithm and how it's applied in certain situations. So I do feel like even if the judge can't understand the engineering process, he or she still may be able to contribute in ways that are positive.
So maybe a brief reply.
Sure. Okay. So first, Sandy, because it's actually easiest for me to reply to Sandy, is I actually agree. When I'm thinking about this, when I say it shouldn't be used, I'm thinking about an adversarial process, I'm thinking about sentencing, I'm thinking about bail reform, or all this, where it is being used to do something to someone. I actually completely agree with you that there are good uses of algorithms that are not those. So cool. Chris, so I think there is some sense in which the very notion of individualized determinations or justice is unspecified throughout law, and it's important that we actually grapple with that, and law certainly hasn't, I think, in a lot of ways. And so to that extent, the whole point that humans are doing stereotypes as well as algorithms is that's a problem. But what I take away from that is when we think about what we want, like the kind of individualized justice we want, we're not thinking about just accuracy and cross-examining the system, whether it's a human or algorithm, for errors, but some other meaningful engagement with the process, the adversarial process, that on a human level. And it's this thing that, maybe it's a circular argument in a sense, but I don't think so. I think there's something, if we care about individualism, it's not on this basis of accuracy. And it never was, but we haven't really figured out what that thing is that we care about. And so I think if we do care about it, we should take that seriously and think about why that means we reject algorithms. And to Christine, I don't think necessarily the issue is just that the judge can't understand the engineering issues, right? It's more, imagine you have a very transparent algorithm that is just a 1 to 10 scale of 6 different numbers, and they're all added together, right? On one sense, you could understand it, right? Like I could take a pen and paper and get the results of the algorithm. I can understand what it's doing internally. But what does it mean to understand something? Right? So it's one thing to say you can understand it mechanically, but it's another one to say that you can understand it in terms of meaningful categories that we decide justice-based issues on. So an example I love to give is there was this machine vision paper where they had to distinguish between a bunch of wolves and huskies, and they created an interpretable algorithm to figure out to run this decision on whether they were looking at a picture of a wolf or a husky, and they got almost everything right except for one. And they're like, what's the thing in the picture that's identifying whether something's a wolf and a husky? And it turned out what the computer highlighted was the snow in the background, not the wolf or the husky, right? And so this is actually usually used for an argument for interpretability. But when you think about that, snow is a category that we all recognize, and we all recognize it as not a determinate category between wolf and husky. So we all laugh, but it relies on our human conceptions of these categories. If instead the computer had recognized some pattern of fur, we wouldn't have any way to say whether it's doing the right or wrong thing. We know snow is wrong because that's in our categories. And that's what I mean when I say that judges can't understand these things. It's because they don't map onto human thought patterns and categories. It's not because they don't understand the engineering, which also they don't.
Great. So I want to throw in a consideration I think has come up a bunch of times, and I'm going to direct it most at Christine, but obviously I'd love it if anyone else wanted to comment as well. And that is to focus on the role of the producer of the algorithmic tool. Generally, we're talking about private firms here because they have the expertise and they have a certain profit motive, which might influence the kind of product they produce and who they market it to and so forth. And I wonder, Christine, how that relates to your very important access to justice theme that you talked about. Is there maybe a shortfall that's inevitable when private firms are, it seems like, producing many or all of the tools, and to the extent that's a problem, are there ways we could have publicly funded or other modes? Obviously there are tools created by nonprofits and so forth. How should we be thinking about these three different sets of producers in this space?
Okay, thank you very much. So one of the things with the private firm influences, I think, is this notion of competition, right? And so like we have multiple presidential candidates and they tend to tear each other down in certain circumstances, well, I think having a lot of private actors who are creating these various tools will actually lead it to be more clear where the flaws are in the other person's tools. Do you see? So then people may become even less confident about all the tools because every tool will have some sort of flaw that is identified. I think the other thing to worry about with the private development of these tools, others have talked about, the importance of it and sort of how much money is being spent and that sort of thing. But the private choices that are made by these companies based on what they're going to be able to fund and what's going to be useful and what's going to be marketable actually has a public impact. And so we're kind of creating public policy by private actors creating these programs that then the government uses, but because they weren't created for the government, they have different influences and maybe different considerations. A lot of those who create these programs, you think about Silicon Valley and how different that is from, your stereotypical person there from a government actor, right? And so in that sense, I think we have an issue. I think another issue that comes up between public and private is if the public company is creating the algorithms, they have an incentive to over comply with the law because they don't want to get caught, they don't want to get in trouble. So think of like TurboTax, right? TurboTax, they create the stuff, you put in your information, they're going to want to over comply, and if it's borderline whether your thing is deductible or not, the program's going to make it be deductible. They're going to design it that way so that you don't get audited and then don't use their product. You see, so incentive to over comply, which then it may be, that leads to other problems. I think when the government is trying to use algorithms to create enforcement mechanism, they have an incentive to kind of under-comply because they don't want everyone challenging their decisions. So I think we do get very, very, very different concerns. And I think the other thing to think about is sort of the efficiency argument. And I kind of, touched on this a little bit, but obviously with the private actors, to be more efficient, you're going to have repetition. Efficiency means outliers don't count because that's not going to help in the majority of situations. Repetition, we want to keep applying it to similar cases, which then gives us proven results that we can say, look how successful we are. But then what we're really looking at is getting more data that will fit our mode so that we end up with the same results. So I think, again, because I consider the private actors, not all of them, but many of them, to be more concerned about market and market share as opposed to public policy, then I think on balance, the private firm influences are taking us in an awkward direction for public policy purposes.
Any other thoughts? Anyone want to jump in? No? If you want to.
Well, I think the transparency point is very interesting. And when I've talked about to some groups, scientific groups, they often ask me the question, well, we have an AI algorithm, that is basically a black box algorithm, that's perfectly accurate. Why wouldn't we always take that? Who cares if it's transparent or not if it's accurate? And I think that's, again, where we have to figure out what our values are. And I personally would opt for transparency over complete accuracy. And I think there's Sixth Amendment law to that effect, too.
So I have one more question I'll ask the panel, and we'll open up to broader discussion. I'm going to direct this one mainly at Sandy, but again, inviting everyone to jump in. So I took one of your main themes, Sandy, to be about the volume of data that we have being a prism or a mirror or whatever metaphor, optic metaphor we want for understanding ourselves and our society and so forth. Do you think that people who view the data-rich environment that criminal justice is increasingly finding itself in, do you think people who view that data-rich environment as a source of optimism on net are well justified in the sense that maybe for the first time a lot of pathologies are visible that weren't visible before, and not just visible to people who are at conferences like this, but visible publicly in a way that could foster political mobilization that came up, I think, especially in the prior panel, where people were talking about different types of controversial policing tools, and then communities that maybe don't often have voice actually were able to have quite a voice that had a public effect. So I just wondered if you'd comment on that with the political dimension layered on top.
Yes.
Yeah.
Yes. I do. I think people who are optimistic on net are justified for exactly that reason. And as a case study, I have almost all of my friends in this realm are resistant to risk assessment, and we're sort of on opposite sides of this debate. In Pennsylvania, where I'm from, the Pennsylvania Sentencing Commission was under a legislative mandate to develop a risk assessment tool for sentencing. And the commission, very well-intentioned, wanted to have a process that involved public input and held a series of community meetings, published all the reports about the data that they were using to develop the tool with the proposed tools, and there was tremendous public outcry, and my friends who are organizers got tons of people to come to the public hearings, and it's been great. It's been a wonderful process of public input and dialogue between affected community constituents and people charged with making sentencing policy for Pennsylvania, in which the data has figured centrally. And the patterns that become apparent when the Sentencing Commission tries to articulate predictive factors are at the core of that discussion. So yes, I think even until this point, the advent of risk assessment has enabled a kind of public conversation on the basis of the data that's become more accessible than that we hadn't had before. And I also, if I can say one more thing, I was thinking as we were talking about algorithms in criminal justice adjudication, which is the subject of this panel. What are algorithms good for? They're good for statistical analysis. They can answer a statistical question. So one way of thinking about this question might be sort of where in the criminal justice process are actors in the system forced to answer a statistical question? And at those points, that's where I think algorithms can be useful. Now, what sentence should be imposed is not a statistical question. Whether someone should be released pending trial or what restraints there should be on a person's liberty, that's not a statistical question. How we should manage a given risk, that's not a statistical question. But there are points in the process where courts do have to ask the statistical question, what is the probability of future event X? And at those points, that's where algorithms can come in.
Or maybe even legislators who make generalized statements.
Yeah.
Thank you, everybody, so much for being here. I learned so much in this talk.
Thank you.
Yeah, thank you.
I didn't mention